proceed, let's pray to Goddess Saraswati. That was established in the year 2004. It is affiliated to Guru Gobind Singh Indra University, Delhi, and is approved by All India Council for Technical Education, Ministry of HRD, Government for India for technical programs, and Bar Council of India for its law programs. We are currently offering postgraduate programs in MBA, MBA International Business, and undergraduate programs in BBA, BBA LLB, and BA LLB. Our institute has been awarded as A grade by National Assessment and Accreditation Council in the second cycle. It is the ISO 901:2015 certified institute. We have been also rated A+ by the State Fee Regulatory Committee, a fee committee of Government of NCT of Delhi, and rated the highest grading A by Joint Inspection Committee of Government of NCT and GGS University. We have been rated Grade A by the Academic Audit Cell of GGS University consecutively for the past 8 years. Our institute has been rated number 2 by Times B School Survey consecutively from 2019 to 2021. And this year, we have been ranked number 1 by Times B School Survey for our BBA program. Another jewel to our success, I proudly state that we have been ranked number 49 in top 150 B schools in India, 34th in top 100 private institutes in India, 19th in top 20 non-B schools for our MBA program by the Times Business School Survey 2022. I feel extremely happy and proud in announcing that our Vice Chairman Sir received the Economic Times Leadership Excellence Awards Nord 2022 in Education by the Economic Times on 22nd August 2022. Now, I request you all to kindly have a look at the corporate video to get a glimpse into the institute.
A promise is what you make for yourself. A promise to explore, innovate, and achieve. It's a driving force that leads you on a path of success. It's all about reshaping your skills, discovering your inspiration, and accelerating it further to uncover your inner potential. At GIBS, we sow the seeds of the global leader, the leaders who behold the power of influencing the world with their expertise and experience. Our vision is to develop business management and law professionals to provide intellectual, emotional, and psychological leadership. Considering these factors, we offer 5 significant courses that are divided into MBA, MBA International Business, BBA First and Second Shift in Department of Management, and BBA LLB Integrated, BA LLB Integrated in Center for Legal Studies.
In a dynamic and ever-changing world, the real challenge is to stay relevant. The skill that is most valued in post-pandemic era is creativity. It is the creative solutions that help us in facing challenges. Can creativity flourish within the boundaries of classroom teaching? I don't think so. We actives create experiences that blur the boundaries between theoretical and practical knowledge. We believe in training professionals who can take decisions and bring positive changes. Come and experience the world with us and let us together make a dream a reality.
We make sure that every student has access to grab all the opportunities that come their way. Here, you will witness diverse kinds of roles offered by companies in various sectors. A student-centric Industry Institute Partnership Cell, IIPC, brings corporate leaders and students on a common platform to be exposed to multiple opportunities in the professional world. The alumni portal of GIBS connects all the alumni on one single platform.
Of Gita International Business School, I would like to extend a very warm welcome to our esteemed chief guest, Shri Surajit sir. Sir, we are highly honored to have you among us today. Sir is presently Registrar Law of National Human Rights Commission. After completing his BSc Honours in Chemistry, Sir pursued his LLM and thereafter his postgraduate diploma in company law and management certificate course in cyber law. A 99 back judicial officer of West Bengal Judicial Services, Sir has worked in various capacities in the West Bengal judiciary and was promoted in district judge cadre in 2013. He has also served as Registrar of the Supreme Court of India from 2014 to 2015. May I now request VC Sir to extend a gracious green welcome to our chief guest.
Thank you, sir. Now, I would request Director Sir, Professor Dr. Binu sir, to address the audience.
Respected R.N. Jindal Sahab, in absentia, our chairman, Mr. Anirudh Jindal ji, our vice chairman, our friend, philosopher and guide, and Madam Jindal, in absentia, and our chief guest for the function, Shri Surajit Day. I got an opportunity to talk to him today. A learned person, a person who has decorated lot of judicial positions. He has been in apex court and registrar. Presently also, he is in Human Rights Commission and Registrar Law. And prior to that also, he has contributed toward the judicial services. The law, sir, as defined by Koch, is gift by the God and practiced by the sages. And it is regarded a very respectable job. In our holy books, in Manu Smith, it is said, Dharmo Rakshati Rakshata. Means the judicial service is to serve the poor people, weaker section who are looking for the justice. And today's day is very important. In Constitution, it is not protecting the human rights, but धर्म की रक्षा करना बहुत बड़ी चीज है. When Duryodhan went to his mother and the Yuddha of Mahabharata was to start, he took blessings of his mother. His mother said, son, मैं तुम विजयी हो ऐसा कहूंगी, लेकिन धर्म कृष्ण के साथ है. जहां कृष्ण होंगे वहां विजय होगी. And that was the reason. Then 100 Kauravas were defeated by 5 Pandavas. And sir, the judiciary, the constitution protects the dharma. And your services are really great in this regard and will always be considered good for the humankind. We are happy that you have spare time to be our chief guest and grace the occasion, and particularly today's stage. I'm really thankful, and we want to listen to you, sir, at this occasion. Thank you very much.
Thank you, sir. I hereby now take the opportunity to kindly request our chief guest, Shri Surajit sir, to share a
Thank you, first of all. Mr. Anirudh Jindal, Vice Chairman. Dr. Jody, Director. My esteemed friend, Dr. Sanjay Dubey. Mr. Jadhav, all the faculty members. I am really delighted to see all of you. It just ignited my old era college days, university days. So don't take this day as a very heavy one. Take it lightly, because life is there. Enjoy the life in the university institutes. Take it as your own home. It is not a place of learning also. It is also a place of enjoyment, entertainment. And law is such a subject you will not read in the institute. What you need to read or need to understand, that's the basics. And thereafter, you keep on learning the entire life. So enjoy yourself to the fullest. Have a friendship with all. Take the lessons from your director and also the faculty, and then keep along in the life. Now, before coming to the today's topic, which is very heavy as per the concept and ideas, I try to make it little lighter. So let me go on with the idea that how I have developed this Constitution Day and what is the purpose of the Constitution. Before going to my speech and discussion with you, I just ask myself, you also ask yourself, what is the Constitution about? What is the need of this Constitution? What will come with that regard to that to a rickshaw puller or even a vegetable vendor or even a daily wage laborer? What's the Constitution about? Samvidhan kya hai unke taraf? But this Constitution is such, it binds them all. We have so much disparity, diversity, economically, socially, politically, from everywhere. But this is the only the small idea that was incepted, this day in 1948, which binds us all. Otherwise, if you see the total perspective, I'll try to develop my speech on that how important it is to unite this country. Otherwise, this country would have been nothing more than that of Europe, the fragmented one, or any of the Western Asia. So this is the only document or the instrument of the modern era which binds a country, which the largest democracy, constitutional democracy rather, and also it is a system Nobody in the world you will find. You have seen the capital hit just after changing over the power from one president to other. What had happened? This is the oldest democracy with so much intellect, but they have attacked the capital hit, which equal that of our parliament. You have seen our neighbors. There is no continuity of their governance. You have seen the Western democracy in the UK. Other day, each of the day, there is a new prime minister is coming. So this is the only document of which, or the instrument which keeps us united, which has not made any person so powerful that he can disregard the people. So this is the importance through which I will try to develop this historical background, then its perspective, how it functions, and how it has united the constitution itself, the maker of the constitution. I will try to develop. Don't take it very heavy on your head, since a long study is required. So I am happy this morning on this occasion of the Constitution Day, which marks the anniversary of adoption of our constitution on this day. In fact, today is the day to the homage to our stalwarts responsible for creation of Magna Carta of Indian democracy and polity. India's freedom struggle lasted almost 200 years, as a consequence of which our constitution, which continues to define basic set of rules and regulations that govern our motherland, came into existence. Binding the country full of diversities, many of languages, dialects, sects, princely states, through the constitution, and to chart out a strategy to move forward was a Herculean task that was beautifully handled by our constitution makers. As you all know, in 2015 onwards, the honor of Dr. Ambedkar was the chairman of the drafting committee. 125th birth anniversary, the Government of India started this 26th November as the Constitution Day, which was previously known as Law Day. Now I will give you what is constitutionalism. The modern political thought draws a distinction between constitutionalism and constitution. A country may have constitution but not necessarily constitutionalism. For example, a country with a dictatorship where the dictator's word is law can be said to be a constitution but not the constitutionalism. The underlying difference between the two concepts is that constitution ought not merely to power on the various organs of the government but also seek to restrain the power from that administrator. Constitutionalism recognizes the need for the government but insists upon the limitations being placed upon the government power. Constitutionalism envisages checks and balances and putting the powers of the legislature and the executive under certain restraint and not making them uncontrolled or arbitrary. So this is the constitution which will restrain the power who is supposed to exercise that power. Constitutionalism connotes, in essence, of limited government or a limitation on government. Constitutionalism is the antithesis of arbitrary powers. Constitutionalism recognizes the need for the government with powers, but at the same time insists that limitations be placed on those powers. The antithesis of constitutionalism is despotism. The idea of the constitutionalism is not new. It is embedded deeply in the human thought. Many natural philosophers promoted this idea over the years. Magna Carta in the year 1215 strengthened the traditional view that the law is the supreme, as observed by author Sunderland. The Great Charter was obviously cherished, a standard, a welcome assurance that people could set some limitation on the arbitrary power of the king. So this was the constitutionalism. So mere constitution will not everything. The constitution is something which will restrain the power of the person who will administer the power. So let us now read the preamble which is necessary for the Constitution Day, as they have also given that paper with me. So if you have the paper with you, please repeat here. May I read? You also read. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic, republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and to promote amongst them all fraternity, assuring the dignity of individual and unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you. So, you understand that this is a preamble. So, I will just develop how the each of the words in the preamble. All right, go it. Come now. Excitement must be there. So, each of the words of the preamble, how these words are being used in the Constitution and how it is real and how it is being implemented in our daily life. That I will try to develop. Perhaps the most remarkable feature about our Constitution is that its philosophy is everlasting, but its structure and process are flexible. Our Constitution framers were enlightened and foresighted enough to give future generations the power to amend and change clauses as may be needed at the time. So this is an aspect that I will come later on, how far the Constitution can be amended and can be changed. The sermons and messages that were engraved on edicts of the Samrat Ashok, who after the war embraced Buddhism after the war of Kalinga, may be seen as an example of rules which regulated the conduct of the general population and the ruling class. He showed the way of development to the nation from social, economic, political, religious perspectives during his reign. He was an advocate of social justice. So it is in our heritage and culture that we have seen that thousands of acts since 1773 onwards. Various acts were passed by the British government for the governance of India. The period of historical British constitutional experiments in India can be divided into two phases. So, Indian constitution has come up by looking into various acts, Government of India acts, various other acts enacted in the British Parliament. You just see, the British have also made the experiment of political theory, how it will be implemented to their subjects when India is under the colonial culture and the colonial rule. First phase was the constitutional experiment during the rule of East India Company from 1773 to 1857, such as Regulating Act of 1773, Pitt's India Act 1784, Charter Act of 1813. The second phase is constitutional experiments under the British Crown, that is 1857, just after Sipai Mutiny, to 1947, once we got the independence. These are the acts. What are those? Government of India Act 1858, just after Sipai Mutiny, the Government of India took over the entire the Indian colony directly under control of the British government. Then Indian Council Act 1861, Indian Councils Act 1909, Morley Minto Reforms, Government of India Act 1990, and Montego Chelmsford Reforms with the Cabinet Mission in 1946. So this is the background through which the Indian Constitution has been built up. Only two major features of Government of India Act 1935 need to be mentioned. First, the Act conferred only a very limited right of self-government on the Indians. The executive theory in a province was vested in the governor appointed by the Crown. He was to act ordinarily on the advice of ministers who were to be responsible to the provincial legislature, which was elected on a limited franchise. But the governor could exercise certain functions in his discretion or individual judgment, in which case he was bound by the ministerial advice and was subject to the control of the Governor General. So this is the concept that was given in this Act of 1935, through which our present government is doing, but it is for the people, by the people, of the people. Previously it was by the Crown, by the rule of the Britishers, that is the King or the Queen of the British. The executive authority of the centre was vested in the Governor General appointed by the Crown. Though ordinarily the Governor General would act on ministerial advice, he would discharge certain functions in his discretion or individual judgment, in which case he was not bound by the ministerial advice, but was subject to the control of the Secretary of State in India, who was the member of British Cabinet. Defence and External Affairs, among others, fell in this category. So you just see the Government of India has given the idea of Secretary of State, who was the British Parliament member, who was supposed to look into the affairs of India, and he was representing the Crown, a British Crown. But the Governor General exercising his discretion, his judgment based on the aid and advice of the Council of Ministers. Same thing has happened in the Indian Constitution also. The Council of Ministers will aid and advise the Prime Minister of the country in the central government and the Chief Minister in the Council of Ministers with aid and advice, exercising the executive power, and they are accountable to the Parliament and the Legislative Assembly at the same time. So these are the theory that has been conceptualized from that Act of 1935. The federal scheme, however, never became fully operative in that Act of 1935, as the princes did not join the federation. There was a princely state, they did not join the federation of the directly control of the British. The federal concept was implemented partially insofar as relationship between the centre and the provinces was observed on this basis. Further, the ministerial form of government as envisaged in the Act of 1935 could not also be introduced at the centre, which continued to function under the Government of India Act 1919. Accordingly, the central government consisted of Governor General and a nominated Executive Council. In this structure, the Governor General occupied the key position, as he could overrule his council on any point if in his opinion or safety, tranquility, interest of British India were materially affected. So there was the time that the Governor General, now we have a concept of the titular head of the governor, who will act on the aid and advice of the Council of Ministers. So previously it was done, but with the aid and advice of the Crown or the Secretary of State appointed by the British government. So 1947, the executive power and the control of Indian administration, which was there with the Secretary of State, the Governor General and the governors, the Indian participation in the governmental process was very minimal and limited before 1947, and naturally Indians were never felt reconciled in such dispensation. There was a representation of Indian to participate in the formation of the administration of the government day to day, which is very limited. The Act was enacted due to growing demand of the constitutional reforms in India by any Indian leaders. There was a huge outcry, that's why the Act was reformed. India's support to Britain in the First World War was also aided with British acknowledgement of the need for the inclusion of more Indians in the administration of their own country. The Act was based on Simon Commission report, the recommendation of the roundtable conferences, the white paper published by the British government in 1933, based on the third roundtable conference. The report of Joint Select Committee was also considered. The Act of 1935 gave more autonomy to the provinces and abolished the provincial levels. The governor was headed the executive. There was a council of ministers to advise him. So they are transforming due to the intervention of the Indian movement, freedom movement, and followed up by the change that has been recommended by the that third roundtable conference and Simon Commission also. The most notable feature of 1935 Act was that the Indian Council was abolished and it recognized several Indian territories. Direct elections were introduced for the first time. The Indian leaders were not enthusiastic about the act since, despite granting provincial autonomy, the governors and the viceroy had considerable special powers. The act was a milestone in the development of a responsible constitutional government in India and was placed by the Constitution of India after independence. So it was replaced by our Act of after independence that has been gone, and so the Constitution we have adopted in formation of that, how it has happened. However, there's a very dark history during that period also, that I'm just reminding that way. It was preceded by darkest time in the modern Indian history when the British rule enacted the Indian Independence Act 1947, which created, unfortunately, two distinct territories of Pakistan and India, led to the most tragic, gruesome communal violence, as you all know. The boundaries between the two dominant states were to be determined by the Boundary Commission headed by Sir Registrar. Both the states had the right to frame their constitutions by their respective constituent assemblies. So 1947, the Independence Act 1947 given the power to the Constituent Assembly to formulate their constitutions. They also had the right to lead the British Commonwealth. With this, the British ceased to have rulers of India and India became a free country. The Constituent Assembly of India was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The drafting committee was appointed on 29th August 1947 with Dr. B.R. Ambedkar as the chairman. Originally, the Constitution had 22 parts, 395 articles and 8 schedules, which later on amended. Dr. Sachinandan Sinha, the oldest member, was elected as the temporary president of the Assembly, Constituent Assembly, following the French practice. Later on 11th December 1946, Dr. Rajendra Prasad and H.C. Mukherjee were elected as the president and the vice president of the Assembly respectively. Sri B.N. Rao was appointed as the constitutional advisor to the Constituent Assembly. It took the Constituent Assembly 166 days altogether, spreading over 2 years, 11 months and 18 days to draft this Indian Constitution, which is the most longest handwritten document. The Constitution of India describes the building blocks of political structure and the duties of the government. It guarantees to every Indian fundamental rights to every citizen. With this Constitution of India coming into effect at long last, it has immense significance. It signifies the complete uprooting of the British dominance. It signifies the country where the people govern its people, thereby truly manifesting the spirit of democracy, which states that of the people, for the people, by the people. So this is the history, how the Indian Constitution has been concepted, how it was drafted. Now I will go, before I go into the other parts of the Constitution, one after another, I will give you a salient features in broad general feature, what is the Indian Constitution about. Now some of the salient features is that it's a written constitution. Several reasons contributed to its prolixity. First, the Constitution deals with the organization and structure, not only the central government, but also the states. Secondly, it is a federal constitution. The center and state relationship is a matter of crucial importance. While other federal constitutions have only skeleton provisions on this matter, the Indian Constitution has detailed norms. Thirdly, the Constitution has reduced to writing many unwritten conventions of British Constitution, as for example the principle of collective responsibility of the ministers, parliamentary procedure, etc. Fourthly, there exist various communities and groups in India. To remove mutual distrust among them, it was felt necessary to include in the Constitution detailed provisions for fundamental rights, safeguards to minorities, scheduled tribes, scheduled caste, other backward classes. Fifthly, to ensure that the future of India be based on the concept of social welfare, the Constitution includes type A principle of state policy supposed to be followed by the state governments and the central government. Lastly, the Constitution contains not only the fundamental principles of governance, but also many administrative details such as provisions regarding citizenship, official language, government services, electoral machinery, etc. In our constitution, these matters are usually left to be regulated by the ordinary law of the land. The framers of Indian constitution, however, felt that unless their provisions were contained in the constitution, the smooth and efficient working of the constitution and the democratic process in the country might be jeopardized. Next is the preamble I already said. Next is the socialistic state, which has been, though it is brought in by an amendment. The word socialist was not there originally in the preamble. It was added to the preamble by 42nd Amendment of the Constitution 1976. Thus, the concept of socialism has been made explicit, and India's commitment to ideal has been underlined. The basics of the social concept is egalitarian society. Equality, there is no difference. Equal pay for equal work. There is no difference. The state should strive to distribute the maximum wealth among the common people. So this is that's why they have not at that point of time incorporated in the constitution the socialist word. The term socialist has not been defined though in the constitution after the amendment. It does not have an envisaged doctrine of socialism in the sense of insistence of a state ownership as a matter of policy. It does not mean total exclusion of private entrepreneurship and complete state ownership of material resources of the nation. In India, there has been an emphasis of mixed economy along with the public sector. The private sector also has a role to play. The government accepts the policy of mixed economy where both public and private sectors coexist side by side. However, the private entrepreneurs have so far been rigorously controlled by the government, but signs are appearing on the horizon that in future private enterprise is going to play a major and important role in important economic role that has not yet been played so far. The Supreme Court in this regard, how they have developed the theory of socialism, has a number of decisions referred to the concept of socialism and has used this concept along with the directive principles of state policies to assess and evaluate the economic legislation. The court has derived the concept of social justice and of an economically egalitarian society from the concept of socialism. According to the Supreme Court, I quote, the principal aim of socialism is to eliminate inequality of income and status and standards of life and to provide a decent standard of life to the working people, unquote. Now, the next salient feature is that of welfare state. The Indian Constitution has been conceived and drafted in the mid-20th century when the concept of social welfare state is the rule of the day. The Constitution is thus pervaded with a modern outlook regarding the objectives or functions of the state. It embodies a distinct philosophy of government and explicitly declares that India will be organized as a social welfare state. That is a state which renders social services to the people and promotes their general welfare. In the formulation and declaration of social objectives contained in the preamble, one can clearly discern the impact of the modern political philosophy with regards to the state as an organ to secure good and welfare of the people. The concept of welfare state is further strengthened by the directive principle of state policy, which set out the economic, social, political goals of the Indian constitutional system. These directives confer certain non-justiciable rights on the people and place the government under the obligation to achieve maximum social welfare and basic social values like education, employment, health. What is the non-justiciable? That means that you cannot enforce those obligations on the state through court of law, but it is the duty of the state to ensure that they should follow that whatever the provision mentioned in the directive principle of state policy with a view to get a kind of egalitarian society, to provide education, to provide work, all sorts of developmental work and for the social justice. Another concept has been brought in which was debated but not included for certain reasons as discussed during Constitutional Assembly, that is of a secular state, which is also later on amended by 1976 and 42nd Amendment. The concept of secularism is difficult to define and has not thus been defined in the Constitution. Secularism has been instated in the preamble by reason of Constitution 42nd Amendment 1976. The object of insertion was to spell out expressly the high ideas of secularism and the compulsive need to maintain the integrity of the nation, which are subjected to considerable stress and strain and vested interests have been trying to promote their selfish aims to the great detriment of the public good. The concept is based on certain postulates. Thus, there is no official language in India, there is no state organized church or religion. Several fundamental rights guarantees freedom of worship and religion, as well as outlaw discrimination on the ground of religion. Thus, by implication, prohibit the establishment of a theocratic state. The state does not identify itself with or favor any particular religion. The state is enjoined to treat all religion and religious sects equally. No one is disabled to hold any office on the ground of religion. This is only one electoral roll on which are formed the names of all qualified voters. There is no discrimination based on religion. So this is the fundamental of our governance. The essential basis of Indian Constitution is that all citizens are equal and the religion of a citizen is irrelevant in the matter of his employment of our fundamental rights. The Constitution ensures equal freedom for all religions and provides that religion of the citizen has nothing to do with socio-economic matters. Though the Indian Constitution is secular and does not interfere with the religious freedom, it does not allow religion to impinge adversely on the secular rights of citizens or power of the state to regulate socio-economic relations. Now next point is the responsible government. How the Constitution makes the government responsible. The system differs fundamentally from the presidential system prevailing in America, United States of America. Whereas the American system is based on the doctrine of separation of powers between executive and legislative organs, the Indian system is based on the principle of coordination and cooperation of the two organs. The popular houses at the center and the states are elected on the basis of adult suffrage. The president and the head of the Indian Union is elected by elected members of the parliament and the state legislative assemblies. This system of election ensures the president is the choice of the people throughout the country and he represents both the center and the state. The head of state of the governor, who is the nominee of the center, and though largely a symbol like a president, yet has some functions to discharge as a representative of the central government. Effective power in the state, like the center, lies in the Council of Ministers headed by the Chief Minister and responsible to the elected House of State Legislature. Next salient feature is that of fundamental rights, which is most important in the Part 3 of the Constitution. The Indian Constitution guarantees to the people certain basic rights and freedoms such as inter alia, equal protection of laws, freedom of speech, expression, freedom of worship and religion, freedom of assembly and association, freedom to move freely and to reside and settle anywhere in India, freedom to follow any occupation, any profession, any trade, any business. And against this right is also there against the double jeopardy and against ex post facto laws, untouchability of age, old scourge of afflicting the Hindu society has been formally been abolished, Article 17. A person can claim fundamental rights against the state subject to the state imposing certain permissible restrictions in the interest of the social control. The grounds for imposing these restrictions on fundamental rights are extremely necessary and mentioned in the Constitution itself. Therefore, these rights are abridged only to that extent laid down therein. So, fundamental rights cannot be abridged except what has been laid down in the Constitution itself. The Constitution provides effective machinery in terms of Article 32 and 226 for enforcement of these rights, these fundamental rights. Without due enforcement, these rights will be of no use. The judiciary ensures an effective and speedy enforcement of these rights. Since the inauguration of the Constitution, many significant legal battles are fought in this area of the fundamental rights, which I am coming later on. Now, another salient aspect is that of the election. India has adopted adult suffrage on the basis of the election of the Lok Sabha and State Assembly. Every citizen, male and female, who has reached the age of 18 and above, has a right to vote without any discrimination. It was indeed a very bold step on the part of the Constitution makers to adopt this policy and determine the millions of people, even literate or illiterate, that they should exercise and participate in the democracy or the formation of the government. To introduce any property or educational qualification for exercising the franchise would have amounted to a negation of democratic principles, such as qualification would have de-enfranchised a large number of depressed or poor people. Further, it cannot be assumed that a person with a bare elementary education is in a better position to vote than a laborer or a cultivator who knows what is his interest and will choose his representative accordingly. This is the most important aspect of Indian Constitution, that there is no, evaluation of votes of a rich people or a poor people or an educated person or illiterate person. This is one of the fundamental salient feature of our Constitution. Now the role of the judiciary is, in the Constitution has given us the separation of power between executive, legislature and judiciary. The role of judiciary is quite different from that of the other constitution, other jurisdiction. Although India and the American Constitution both are federal in nature, Indian judicial system differs from that of the USA in a significant respect, but the USA is a dual system of courts in federal judiciary with the Supreme Court at the top, along with a separate parallel judicial system in each state. India has unified, not a dual system of courts. Supreme Court, High Court, District Courts are constituted a single unified judiciary, having jurisdiction over all cases arising under any law, whether enacted by Parliament or the state legislature. So this is the basic distinction. Now the federal concept of the Constitution. Indian Constitution is a federal in type. It establishes a dual polity in two-tier government system, rather three-tier. Now local bodies also being represented by the election, that is the panchayat and the municipalities also. The central government is at the one level and the state government other, and the local government is also there. The Constitution marks of the sphere of the action of each of level of government by devising an elaborate scheme of distribution of legislative, administrative and financial powers between central and states. A government is entitled to act within its assigned field and the features of the Constitution. Now, I am coming into the area how the Constitution over the almost 74, 75 years of independence, and then the Constitution was adopted from 1950 onward, how the history has developed with the Constitution, how the judiciary has intervened, that I will try to tell you. First of all, there is a provision in section 13, which is within the part 3 chapter, within part 3. What it says, just in short I am telling you. Article 13 says, laws inconsistent with or in derogation of the fundamental rights. But it says that all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with provisions of parts, shall be extended to such inconsistency void. Second, what they are saying, the state shall not make any law which takes away or abridges the rights conferred by this part, or any law made under the contravention of this clause shall to that extent contravene be void. So basically this is the two basic concepts to which you cannot prior to the adopting of the Constitution, whatever the law, if it is inconsistent to that of the law, the articles provides in the Constitution, that will be declared to be void. Or even if you enact some law, then if it infringes any of the part of the Constitution, mainly the part 3 of the Constitution, that will also declare to be void. Now the tussles have started. How it was started? See, previously, if you see in the Constitution, right to property was one of the fundamental freedoms. Right to property was also enacted in Article 19. Later on, by an amendment, it has been deleted from the part 3 chapter. It has been given in a separate part, that is Article 308. So long as the right to property was a fundamental right, the distribution of wealth, because you see there is a conflict. If you read part 3 and part 4 at a time, you will find that here they have given individual right to every individual for their welfare, for their own improvement. But at the same time, the part 4, that is the directive principle of state policy, has given the power to the state for welfare of the people, for development of the state. Suppose if you see any of the then Sajjan Singh, then Sankari Prasad, Goloknath has also not decided. So what the Goloknath has said, that yes, you can change the Constitution, but not to that extent to which the fundamental rights have been given. So this way the debate has come up. finally, in the Keshavananda Bharati's case in 1973, the Supreme Court has evolved the concept of basic structure. The Keshavananda Bharati judgment defined the basic structure of the Constitution. The Supreme Court held, although no part of the Constitution, including the fundamental rights, was beyond the Parliament's amending power, but the basic structure of the Constitution could not be abrogated even by constitutional amendment. This is the basic Indian law in which judiciary can strike out the amendment passed in the Parliament that is in conflict with the basic structure of the Constitution. So there is a basic structure as doctrine has come up. What is the basic structure? Suppose the Constitution itself has given to the Parliament to amend the Constitution itself. Now how far you can amend? Can you change the entire altogether the concept of the Constitution? Ultimately in Keshavananda Bharati the Supreme Court has developed that no, you cannot. There are certain basic structure of the Constitution. What are those basic structure? The salient features that I have mentioned to you: center-state relations, federal concept, then your fundamental rights, the right to life and liberty that cannot be abridged. All these are basic structure, including judicial review. So, lot number of criteria have been put in that you cannot touch upon. And then they have developed a very unique thing which is not happening nowhere in the world. That's why the Indian judiciary, rather the Supreme Court of India, is arguably the most powerful court in the world. They have developed a concept of judicial review under Article 32. They are saying whatever the law that you can enact, any person, any individual can go and challenge it. And under judicial review, the court is empowered to examine the law based on the constitutional provision. So finally, if you see in 2015, this is a unique case of supremacy of judiciary because three organs are there: executive, legislature and judiciary. Role of the executive is to formulate the law, enact the law. Legislature to enact the law in parliament or in the assembly. Executive to execute the law or to implement the law. And judiciary to examine the law, interpret the law, and finally to examine or review whether the law is correct or whether the law is constitutionally intra vires or ultra vires. So their power, that's the example that I am trying to give you, that is the National Judicial Accountability Act, that's the NJAC Act. What had happened in that, it is a very tricky issue is there. There was an article, there is an article 124. How these things have come up, I am trying to give you a little bit of idea of it. Article 124 says that establishment of Constitution of the Supreme Court. There shall be a Supreme Court of India consisting of Chief Justice until Parliament by law prescribes a large number. This is there. Now every judge of the Supreme Court shall be appointed by the President by warrant under the hand and seal and just conclude. At the end, I will leave to you the words of, I just remembering the Mahatma Gandhi what he said, I quote, in every decision we take, every measure we consider, we must ask ourselves if what we are about to do will be of use and benefit to the poorest and weakest person we have made, and in some manner restore this person control over his or her destiny. And this, I believe, truly embodies the spirit of the Constitution, unquote. So at the end, it is the Constitution which gives us the power
and it's what it determines that firstly we are Indians and lastly we are Indians.
And now, the much awaited interaction session for the audience is open. We're going to be taking questions from the audience that you can ask from our respective chief guest. So the interaction session begins, and I'll be coming towards the audience. Any of you who have questions, kindly raise your hand. I'll be coming towards the audience.
So since I was not a good student like you, so I have brought in my colleague, and he is a very bright person. Dr. Dubey will give the answer. I'll be his assistant. Yes, come on.
Good afternoon, sir. Myself, Surajit. As you know that constitutional morality is deeply rooted in the constitution itself.
I request everyone to please maintain some silence. Thank you very much.
As we know that constitutional morality is deeply rooted in the constitution itself and is founded on the essential facets. Can you please enlighten us on the doctrine of constitutional morality with the help of relevant judicial decisions so that we can understand this doctrine more thoroughly?
You see constitutional morality. I'm giving a live example, otherwise it will be a no question of this thing. I'm giving a very simple question, simple answer. What is constitutional morality? The thing is that there is a provision of appointment 324, appointment of election commissioner. Now, the provision has set out this thing, that this who will be what is the process of or the role and play and all this of the election commission now. An appointment procedure is laid down. Thereafter, a law has been enacted. Now, how the constitutional morality has come on telling you? Recently, Mr. Agarwal has been appointed as the election commissioner. Now the question that it has been a 5-judge matter is going on, is the subjudice matter, so I am just going back to the intricacies of that, but I am giving the example. The process has been, the public interest litigation has been filed, saying thereby the government of the day is appointing the election commissioner, and those election commissioner based on seniority is the chief election commissioner. Now, what process that they have been adopting by selecting those persons? Is it the pick and choose? Is it the yes man of the government? Or what are the objective criteria of that? While doing that, there is a balance of power. Now, the government's answer is that you cannot go into the domain of governmental function because government is being elected by the people of India. So they have the mandate to exercise their power given in the constitution and the law by thereunder. But Supreme Court says no. We are not going into the nitty-gritty of how we are making it. We will see the constitutional morality, that whether you are picking up someone, the question is raised that there are 40 similar type of persons are there. That is the question of Article 14. Similarly, equally eligible, equally competent, equally this person can also be appointed. Now, how you have picked up only 4 persons? From there, you are selecting one person. That too, within a period of, as it has come up in the media also, and it is seen in the live telecast, so another occasion to listen to the argument also. And in a day. And also, notwithstanding the fact there is no injunction, that is, since the matter is going on in the constitution bench, there is no injunction of stay. Now the court says that once the matter is going on, why in a hot haste? Why in such a electric fire way, one day, less than 24 hours, you are selecting one election commission? This is some kind of idea of constitutional morality. That means that I said at the very beginning that what is the distinction between constitution and constitutionalism? Constitution may be there in China also, there is a constitution, but you hardly find that any kind of individual's right has been, I don't know, but it is privacy observation that whether those have been protected like the way it has been happening in India. So there is a constitution in other country, autocratic country, but there may not be constitution. Constitutionalism means to limiting the power of the government of the day or to restrict them within their parameters. It has not been laid down. Constitution says that yes, government is entitled to appoint the election commissioner. Constitutional morality will come in that way, that procedure has not been laid down. The enactment, Parliament Act is also there, that has also not been given. What should be the procedure? Like in Lokpal, or like in the Supreme Court judge appointment, there is a procedure laid down. There is a select committee, search committee, they will select the person, then thereafter there is a high pedestal, high threshold, because they must be above all interference. Okay, similarly our Protection of Human Rights Act, there is a procedure laid down. Whoever there is the appointing committee, how the appointing committee can select and whoever the person. Now constitutional morality will come that government ignoring everything, they are going in their own way, selecting their own person in the guise of the constitutional permission. This is the constitutional word.
Thank you very much, sir.
Anyone else?
A very good afternoon, sir. First of all, thank you for the great session. My question is, sir, since courts are more concerned towards the legality of the law rather than more for the morality. So, what if a law which is made is legally and legally perfect, like correct, but it is not morally, ethical? It's not ethical. It's constitutionally legal. It's constitutionally fine, but it's not morally good.
Give us example.
But it happens, like sometimes.
Give us one example. That a law that has been enacted, which is constitutionally approved, or that what are the challenges of any law? There are 3 points there. First, legislative competence. That means 7 signals given the list, central list, state list, compact list, whether it comes under that list. First, competence. Second point is arbitrariness. Arbitrariness is that what? That any provision or whole of the act is not infringing any of the provision of part 3 of the Constitution. Third point is there, which is a very dynamic subject, which the state, which the court always interpreted this way or that way. That is what the object and nexus. There is every act, there is an object, statement of object. Now, the provision, you have a lofty idea, lofty object that some international covenants have said this, that India should make a kind of socialistic state, then the social justice. But
Can you stop? You sit there.
provision of the act may not have any direct nexus. Okay, in that case, the law can be challenged. Like, I'm giving an example. The monetary executive action, the demonetization was happened. The time was given 31st December, that it can be changed, it can be, that time, by that time you can change the currency and all. So basically, the object is a very lofty idea, but you are putting the persons in trouble. Morally it is, or ethically it is very hard, very harsh. Those who are abroad, those who are having some kind of treatments going on, how do they change the currency? So here, your question is that if you tested that yes, in practical what has been done, it cannot be accepted in a democratic society. Even if it is legal, the power has given to the government. RBI can issue the notification, ordinance was made. But whether it is morally acceptable, so that question is also a question to look into. Supreme Court is also looking to find the constitutional bench of the legality and morality of that, of the act of demonetization of the notification. So let us wait what finally does happen.
May I now request Professor Dr. Sanjay Dubey sir to exchange the vote of thanks.
Now it's the time to conclude. First of all, good noon to everybody here. Remember, today we all are celebrating the Constitution Day of India. But it is the day. Why? Because it is the day when it was enacted. It is the day when it was adopted. And it is the day when partially it was implemented. We find also, we can call it the Constitution Day as an adoption day, it's enforcement day, it's an acceptance day. It is all about the acceptance of the Raj Dharma, as director has told us initially, Dharati iti dharma, जो हम धारण करते हैं वही धर्म होता है, and राष्ट्र धर्म is above all. That is what the Constitution speaks about. Friends, also remember Constitution of India is the supreme, sacred, legal document of the nation. There is no law, there is no profligacy, there is no religion which is above than this one. This is the towering beacon light for everyone if they are confused. Remember also, friends, that is the reason the Constitution is called as the mother of all laws. There is no law which can assail over it. It is the prudence and the precedence of the Constitution that has to subsist and make a substance of the life. Friends, since it is the mother of all laws, it is for this effective reason we are finding this day has been and is being celebrated as the National Law Day. Friends, legislature, executive, judiciary and all other institutions and organs, they fall in line to the Constitution, and we are finding that that makes the roots of democracy very strong. So lastly, to coming to the specific point, friends, I want to remind you, don't forget that ours is the lengthiest constitutional document of the world, and ours is the world's largest democracy, and we must not forget that we are the oldest culture of the world. Despite being तलवार से कटती नहीं, सभ्यता है धूल की लहर जो कभी मिटती नहीं। My ideas and hearing at length our chief guest, Sri Surajit, really feel honored, and we find the entire deliberation, the interaction, and all about what is unsaid or said. Please remember, this conclave has been converted by our chief guest, not a conclave, but a satsang. Satsang on the Constitution of India means catching the spirit and essence of the Constitution of India. We are indeed proud that amidst us, Sri Surajit ji, who is the currently Registrar of the National Human Rights Commission, happened to be Registrar of the Supreme Court of India. He is amidst us. He has shared his view. He has made valuable sharing of his time with us. We indeed get touched, and sir, we are feeling proud of yourself. We are feeling proud that we are with you. We are feeling proud that these moments come. On this occasion, Sri Surajit Day Sahib made it a day of happening. It is an auspicious day, but it is a momentous day. We have to remember. Now giving the thanks also to the Vice Chairman of our institution, Mr. Anirudh Jindal. He is the moving spirit and the inspiration behind what we see, what we do, and what we carry on for the future. We are thankful to him too. My thanks also goes to the director, Mr. P.C. Johari Sahab. He began with the dharma. Dharma doesn't mean the religion. It is also related to the kartavyas of life, the anushilan of the jivan. And that is why the concept given by Mr. Johari, that was all about this celebration. And beyond that, sir, we remain grateful to you that every nitty-gritty of the organization and providing administrative and collateral support to this function, and for that we remain indebted to you. My faculty members, who are worthy and learned colleagues of mine, they are my brothers and sisters. I owe my gratitude to them. You are my Humsafar, you are my Humnawa, and your contribution is invaluable. They have given their very best to make this function a grand success. Dear students, We are grateful to you for the reason, and we will remain grateful to you for the reason that you are the purpose of this institution and we teachers. Remember, you are the budding citizens of the country. The future is in your hands, future is in your heart, future is in your brain. Your every conduct speaks about, and that speaks about what will be the future of the country. I hope future of the country remains safe, better with you, and you will move ahead. Instead of, as a teacher, as a parent, I can't say you thanks, but I can wish all the best. Good luck to you, all my dear listeners. In the end, I thank to the invisible and visible support provided by the supporting staff, those who have made the day-night run and made this function to happen in a very smooth, harmonious way. With these words, again and again, my standing ovation to our chief guest, and good luck to all of you. Thank you.
Fraternity, in addition to the protections of justice, equality and liberty. In keeping with the idea of fraternity, we have come together today to celebrate the future's reflection and vision. I would first like to introduce you all to the Institute. Geetharathan International Business School was established in the year 2004. Geetharathan is affiliated to Guru Gobind Singh Indraprastha University, Delhi, and is approved by All India Council for Technical Education, Ministry of Azadi, Government of India for Technical Courses, and Bar Council of India for Law Courses. We are currently offering postgraduate programs in MBA, MBA International Business, and undergraduate programs in BBA, BBA LLB, and BA LLB. Our institute has been rated an A grade by the National Assessment and Accreditation Council in the second cycle. It is an ISO 9001-2015 certified institute. We have also been rated A+ by the State Fee Regulatory Committee, a fee committee of Government of NCT of Delhi, and rated the highest grading A by the Joint Inspection Committee of Government of NCT of Delhi and Guru Gobind Singh Indraprastha University. We have been rated grade A by the Academic Audit Cell of Guru Gobind Singh Indraprastha University consecutively from the past 8 years. Our institute has been rated number 2 by the Times Peace School Survey consecutively from 2019 to 2021. And this year we have been ranked number 1 by the Times Peace School Survey for our PBA program. Adding another jewel to our success, I proudly state that we have been ranked number 49 in top 150 B schools in India, 34th in top 100 private institutes in India, and 19th in top 20 North B schools for our MBA program by the Times Business School Survey 2022. I feel extremely happy and proud in announcing that our Vice Chairman Sir received Economic Times Leadership Excellence Award, Notch 2022 in Education by the Economic Times on 22nd August 2022.
Now I would request all to kindly have a look at the video so as to get a glimpse of the institute. Collection of articles introduced the Indian Constitution goes far beyond that. In addition to establishing and empowering India's institution of government, it has significant other advantages. As a matter of fact, studies have referred to the Constitution of India as a transformative constitution. Now, on behalf of Geetharathan International Business School, I would like to extend a very warm welcome to our esteemed guest of honor, Srimati Binu Tamta ma'am. We are highly honored to have you amongst us today. Ma'am is presently Senior Advocate at Supreme Court of India. She has been handling cases in the Supreme Court right after from 1980. Apart from its private clients, she has also conducted cases on behalf of authorities like MCD, DSIDC, DFC, and Tehri Hydro Development Corporation in the Supreme Court. Presently, she is conducting cases on behalf of UPSC and DDA.
May I now request Director Sir to kindly extend a green welcome to our guest of honor.
Constitution Day, the day when Constitution of India was presented and implemented by the committee. Dr. Binu Ambedkar chaired the committee, and the day has been devoted for the Constitution. Even our Registrar of Human Rights Commission has in detail described the provisions of Constitution, how these were taken from the Act of 1935, and also certain important provisions are adopted from different constitutions. And in the biggest democracy of the globe, our Constitution is being recognized as one of the best, providing justice, equity, and all sort of protection to the human right. This profession and the students who are studying law in GIBS are fortunate enough, as there are ample opportunity in the field of judiciary. Lot of tendency is there, lot of judges are to be recruited, both at the lower level, higher judiciary and state judiciary services. Besides that, you will have opportunity in corporate world, industrial world, banks and other places where you can get the employment. I will be failing in my responsibility if I do not talk about the chief guest. She is a learned person in judiciary, both as an advocate of senior structure. She has been dealing with lot many cases. She herself is a senior advocate. Being senior advocate is a very high prestigious position, and apart from that, it is heard that she is going to be elevated on still higher positions, either within business school. Congratulate Madam for this prestigious assignment, and hope she will do well to provide justice and equity. Law is very important, and as I have been telling, that it is pious field. You provide justice not only to the poor, but also the weaker class of the society. They are deprived of certain facility in the democracy, and the role which Madam is doing is really appreciated. We all join together, welcome Madam, and also to the chairman and vice chairman of the institute, whose vision for organizing legal events for last, I think, a week. We have been organizing debate, moot courts, essay competition, and so many other competition. And in that series, it is Constitutional Day today, which was earlier regarded as Law Day. So at this occasion, I congratulate you all, and especially the type of constitutional provisions which were told to you will enrich your wisdom, and I hope best to you. Thank you.
I hereby now take the opportunity to kindly request the guest of honor, Srimati Binu Tamta ma'am, to share a few words of wisdom.
Namaskar to everybody. A very good afternoon, and I must thank everybody first of all, and the director, the vice chairperson, the faculty members, the students present here. Today we all know is a Constitution Day, and I will not really take like a class here for Constitution, because Constitution is a very wide subject, and it's a basic and the major document of our country. But yes, an overview of an ideal world, that of course I would like to take you an introductory thing, how the Constitution is. It is my first of all pleasure to be with you all on the occasion of this Law Day function. We all know the Constituent Assembly, headed by Dr. B.R. Ambedkar, after deliberations for almost 3 years, finally drafted the Constitution, which our country adopted on the 26th of November 1949, and since then we have been celebrating this day as the Law Day until it has been rightly renamed by our Prime Minister, Shri Narendra Modi ji, as the Constitution Day. We have every reason to be proud of and to celebrate this unique occasion. Let us take this opportunity to thank the founding fathers for having evolved this document, which marked the transfer of the colonial power and the colonial era. It must be appreciated that the need at that point of time, when the country took the freedom from the British rule, was for a governing document of the people, for the people, and by the people. This is how the founding fathers spent a good deal of their time and energy in giving shape to this Suprema Lex, which introduced an organic structure to guide the future destination of the country by a democratic setup to uphold the rule of law. We as citizens of this country are ever grateful to them. The Constitution, it is a fundamental document that covers the union, the states, the local governments, all the 3 limbs of the government, the legislature, the executive, the judiciary. They draw their power from the Constitution. It is the Constitution which gives dignity, protection, and freedom to an individual. Therefore, Constitution is not merely a law, rather it makes the law. At the framing of the Constitution, the Government of India Act 1935 was in vogue, and it largely influenced the framers of the Constitution. However, by that time, there were a large number of countries which were having their Constitution, and the framers took into vision the Constitution in those countries. And as a result, the best elements of those different constitutions of the world have been put into it. I will just give a few examples of it. Liberty, equality, and fraternity have been adopted from the French Revolution. Single citizenship and parliamentary system, or what we call as the Westminster government, are the replica of England. Federation, fundamental rights, supremacy of constitution, independent judiciary, and judicial review are taken from the United States. Directive principles of state policy are adopted from Ireland. The provisions of emergency have been taken from the German constitution. The phrase, India is a union of states, have been lifted from the constitution of Canada. The concurrent list in the constitution has been taken from the Australian constitution. This is how we have got the best constitution, and which has worked over the years, and have, as a result, India has emerged as a big power, as a big democratic country. It would be relevant to refer the words of Mr. Nani Palkiwala, the eminent jurist, which you must all have known and read. That constitution represents the charter of powers granted by liberty, and not charter of liberty granted by power. There is much difference in the two. Liberty is not the gift of states to people. It is the people enjoying the liberty as citizens of the free republic who have granted power to the legislature and the executive. Our country is surrounded by various kinds of diversities, but the constitution is one which unifies everything. It recognizes the identity of all citizens of different genders, having different religion, caste, custom, culture, and language. We all in our school days, as students, of course now you people are all in the law colleges, have read the preamble of the Constitution. The preamble of the Constitution is framed with great care and deliberations so that it reflects the high purpose and identifies securing of social, economic and political justice for all citizens. These are inalienable facets of our Constitution and cannot be amended even by the Parliament. The peculiarity of our Constitution is that it is taken as a living document. It takes into account the changing needs of our society and therefore is amenable to amendments, providing for social and economic transformations. In other words, Constitution is not a static document. It is a flexible and a dynamic document involving nearly 105 amendments, leading to significant changes and new legislations. Therefore, Indian Constitution is the most amended national constitution in the world. But at the same time, the amendment is not permissible to alter in any manner the basic structure of the Constitution. The phrase, basic structure, which you all must have come across by now, I am sure, implies the principles grounded in the Constitution, which can be culled out from the preamble itself, from various articles, and also the concepts of the Constitution, that is like separation of powers between the legislature, executive and the judiciary. Also, the concept of independent judiciary and the power of judicial review, which has been introduced by the courts in interpreting the Constitution, also constitutes the basic structure. In a democratic country like India, judiciary plays a very, very important role in the governance of a welfare society. As the custodian of the fundamental rights and also the freedom of the citizens. Any infraction of any fundamental right, of any basic right, we rush to the courts. And in this awareness, we people are aware of our rights and we approach the courts. And that is how the public confidence has developed in the Institute of Judiciary. Access to free, fair, quick and speedy justice is a constitutional guarantee. It is only by adhering to the rule of law that we can seek to deliver timely and quality justice, as envisaged in the Constitution, and also which reinforces public confidence in the judicial justice administration system. So the independence of judiciary and the legal profession are therefore the inbuilt principles of the rule of law. The Constitution of India provides fundamental rights to the citizens with reasonable restrictions. However, the responsibility to protect these rights of the common person has been casted on the judiciary and the legal profession. The judiciary has given life to the Constitution by giving it more meaningful and practical interpretations over the period. The role of the courts in all these years had been to transform the traditional judicial system towards judicial activism, taking judicial notice of the changing needs of the society and evolving new alternate disputes resolution system. Although today we all hear about PILs, very common, everybody knows PIL, but how it really started, the acceptance of public interest litigation, what we call as PIL, was started just by way of a letter to the court in 1981 for the release and rehabilitation of the bonded laborers. And since then, and after this historic event, various issues of public importance had been raised before the constitutional courts by public-spirited individuals, and this has also added to the great public confidence in the judiciary. The directive principles of state policy vis-à-vis the preamble sets out the goals to be achieved, which are fundamental in the governance of a nation. The 42nd Amendment introduced the concept of providing legal aid in all the courts to the needy and the poor people to enable them to get justice. The wide concept of protection of animals and the environment so introduced have attained much importance over the period with the intervention of the constitutional courts. The common example would be, like the traffic even, the vehicles are being, set out with the criteria as to which kind of vehicle will move and what time it will move, the industries where they will be established, and other protection norms which have been incorporated in the statutes. I feel it is necessary to refer to the concept of mediation to resolve disputes by out-of-court settlement as a great pathway in the administration of justice. It leads to a win-win situation for both the parties by saving time, money, and with no hard-burning on either side. So this is the very, very important development where parties are sent for mediation by the courts, even pre-litigation stage and also during the litigation period. This is a step which we should really take forward, much forward. Initially the mediation was adopted only in matrimonial matters, then to other family matters. And now it is spreading in all spheres of law, whether it is a service matter, insurance, or even otherwise commercial issues. over the period, the Constitution has really made us grow and feel confident. And today is the day when we have to reconnect once again to that past when the Constitution was drafted, the scenario in which it was drafted, and the changes which has brought in our lives. Soon most of you would be joining the legal profession. Soon most of you would be joining the legal profession. So one must remember the peculiarity of this profession, that it is known as a noble profession. What the lawyers do affects not only an individual, but the administration of justice, which is the foundation of any civilized society. The judiciary can discharge its obligations in the administration of justice only with the absolute commitment and active participation of the lawyers. An advocate, which most of you would be aspiring to be, is an integral part of the administration of justice. He is an officer of the court and a friend of the court. He is answerable to the court, but at the same time, he is answerable to his clients, whom he represents in the court. In that view, the critical position enjoyed by an advocate, in fact, imposes a responsibility upon him or her to ensure that justice is made available to all. We lawyers are expected to uphold the traditions of the profession and serve the society with sincerity and honesty in the nature of legal aid, advice and advocacy. What is really needed is the genuine effort which never goes waste. Ultimate allegiance is the set of principles and not to the profits or perks of any profession. Since you people are young and are aspiring to come to this side, it must be very charming and it must be looking very glamorous that lawyers live a very luxurious life. But the hard work and what we call is to burn the midnight oil, that has to be also kept in mind. I express my gratitude to the organizers for having organized this function and also for giving me this opportunity to share my views with you all. As I would like to say one thing, I may not be mistaken, but yes, I will make an effort and attempt. Having practiced law for a long time, I would like to give some practical advice to you all, that initial years of any profession, particularly the legal profession, are years of learning, imbibing, sharing and accepting. This is a little fundamental, that when you enter the profession, you have to maintain the ethics of the profession also. So my good wishes to all of you for your future endeavors. I would like to conclude this speech of mine by the words of former Chief Justice of India, Shri S.H. Kapadia, when he said, which he said on the Law Day celebrated in 2011. When an institution...
We are not getting clarity.
Ma'am, this question is that how we can balance our studies with the internship.
See, this internship has started over the period now. When we were studying law,
This concept of internship was not there. And what we were given were the cycloside copies of the judgments, the important judgments like the Keshava, Nanda, Bharti, Minerva, Vaman Rao and all those judgments in the Constitution.
and we used to read them and study and understand the arguments and the conclusion by the court and the reasoning of the court. Now when this internship has started, yes, of course it is helpful and you should participate in it. But what I personally feel is, yes, internship, first stage should be when you spend time at the office of the lawyer. How a petition is drafted, what points are taken and how research is to be done. This basic concept when you understand, and thereafter if you are physically present in the court, whether as an intern or even after passing the law, you have some basic idea to understand how the arguments are going. So first you need to understand that what is your level of understanding is. Like first year, of course, it's a very, law is a very different subject. Although it is a practical subject, because what's happening around us, we know that is related to law only. So first year, of course, you people should first concentrate on your academics. And I think it is only from the second year or third year that they prefer to have interns. So that is the right time to join. And even then, instead of just spending time in the courts, it is much of the work which is done in the lawyer's office.
Kindly come to the stage.
आगे चले जाओ, फ्रंट से।
Congratulations. Next up we have the winner for the competition of poster making, Anushka Kishwar. She's been awarded with a certificate and a 500 rupees from voucher. Moving forward with the slogan writing competition.
For slogan writing competition, runner-up is Pragati.
Can we have a round of applause for the winner, guys?
And winner for the slogan writing competition is Misha Kalyar.
I and my co-host on behalf of Center for Legal Studies teacher at the International Business School congratulate each and every winner present here. You have done a great job. Congratulations to all. And now,
may I kindly invite Director Sir to present the memento and token of appreciation to the guest of honor.
To one and all, I think you can maintain your silence because you smile more when the occasion of vote of thanks comes. So it is one more smile. Friends, it was quite an illuminating speech on the occasion of the National Constitution Day of the 76th Independence Year of India. We must have to remember that the tenets, essentials and all that setting apart what is said and what is going to be said in future, we must have to remember we are the only few countries of the world in two contexts. Those who have been living with our constitution for the last 76 years with 105 amendments. But on the other hand, if you look around our neighboring countries, Nepal, Bangladesh and Pakistan, all countries have failed and they have got 2 and the 3 constitution till now. That speaks the strength of our democracy. Moreover, friends, the preamble of the constitution, which consists of the 85 words only, and the very first para speaks what kind and character of our system, which political system of India is, that based upon 5 mantras, means polity of India is on sovereign, socialist, democratic republic. But so far as the entire constitution has been facilitated with the objectives to promote just one, that the minorities in India, their number has not reduced. Their number has always been increasing. This is the strength of the democracy. But if you see the same Pakistan, you see the Bangladesh, the minorities population has been reduced to more than 60%. Means their democracy is a pseudo democracy. Means minorities, they have no right to survive, yet they are surviving and struggling. Whereas in India, question of number, the question of their reduction is a non-issue. The only one minority that is called the Parsi community, which is reduced to the population, it is being reduced, it is reducing subsequently. We are finding it has reached to about 60 or to 70,000, and it is because of their biological, you can say, the region, and reasons are quite obvious to know, because they have been marrying within their own families, and for that a lot of criticism has been there. Now the Parsi community is now seriously considering over, and they are become serious that how to enhance our potential and strength. And moreover, the democracy of India, one thing again important for us to hear, friends, we are the monumental democracy of the world. Why? Because all the parliamentary democracies of the world, if you club together, even 2 times larger than is the democracy of India. Means the parts of the democracy world over is spread over, compounding to the whole of the democracy. That is the India, the largest one, that is the tallest, biggest and surviving and enduring democracy of the world. And there is no country in the world you will find, friends, where with such a vast number and variety of, you can say, the differentiations, the pluralities, and so many religions 7 in number, languages officially coded as 1622. So we are finding, not only in terms of the land, geography, religion, language, this much diversity is not seen even into the history by any country of the world. Friends, our India is a hub of the humanity. Humanity of the 1/6 of the population of the world. Means what? Every 6th Indian is, every 6th person in this world is an Indian. And that Indian is who? We are that Indian. And we are carrying on our shoulder the nomenclature of the Mother India. With these words, friends, I would like to draw the attention that ours is not the nation of democracy, it is a democracy of democracies. Ours is the humanity of all the humanities. Ours is the unity of all the unities. And moreover, it is the cradle of civilization, the oldest civilization in the world, which has been attacked. We have bleeded like anything, but despite that, our color of blood yet remains the one that is called red. Friends, remember that we are proud of our nation, proud of our constitution, and proud of our democracy. Apart that, we also know that democracy of our country is totally different. And as Madam has elaborated, the insignias of the democracies, the intricacies involved into the democracies, but I would like to say, friends, no country in the world you will find where there is a perfect constitution. There is no country in the world you will find there is a perfect law. It is the people, those who make the worst law into the best law. It is the people who make the best constitution, the worst constitution as the best constitution, and in that way we have exemplified that. Those who have those who are not complicit with the present constitution of India, friends, remember, बना सके न जो अपने को वक्त के काबिल, वो बात करने लगे बेवफा ज़माने की. There is no person in this world who is perfect. I suppose all of you examine, introspect yourself. Nobody is perfect. If you get perfect in one thing, you get disperfect in another thing. Life, thy name is of balance, harmony and happiness. Live with your deficiency with all proud. No problem. Try to make use of it as a resource, an asset and potential of yourself. In the extension of these words, on this occasion of the gala function that is called the National Constitution Day of India, friends, this is an occasion where we have witnessed one of the leading luminary of the country, that is our Madam Binu, who is the judicial member of the taxation appellate, you can say, that is called involving custom, service and all taxation, and the appellate, you can say the mandate, not the tribunal, it is an appellate tribunal. It is a tribunal at the higher pedestal where the review of the all judgments made by the tribunal is being heard. You can say, as into the court's hierarchy, the appeal of the district court goes to the higher, right like that. It is an appellate tribunal where Madam is adopting the position, and I suppose with a clean heart and clean vision and perfection of the ideas, she will deliver the best to the society what we look for. Friends, her benign presence has made this function sacrosanct. She has graced this occasion, made it valuable for all of us, and she is the only one. She is radiant upon all of us. Madam, you have graced this occasion in this Vidya Mandir in a great way, that is called as the Gita Ratan International Business School, and we hope to listen to you more and more. You will spare some time. We will soon knocking the door of yours very shortly in the new year, and I hope, like as usual, never you will say no. Now, Madam, no words are suffice to appreciate or to give you thanks. I don't want to give you thanks because it involves somewhat formality. But Madam, we are touched by you. We want that on this occasion, though I am compelled to vocalize my thanks to you, but Madam, we are having gratitude for you. And it is coming out from the very fathom of our heart. Kindly accept that, though I don't have any flower cross. Thank you.
Thank you, sir. With this, we end today's valedictory session of the Constitution Day celebrations.
Students, kindly be seated as the guest departs.
पूछ लो